I'm Michelle Johnson from the Tennessee Justice Center, and I'm going to talk about health care. And just stop me if I get to talking too fast. So, don't know how to forward the back here. Okay, so we're going to talk a little bit about who TJC is, then talk about the Benta B case, where we have lots of pro bono opportunities, Wilson case, choices, and then leave some time for questions. But if you have questions throughout, please feel free to stop me, because, of course, healthcare is fairly complex in Tennessee and in America. So the Tennessee Justice Center, we've been around for about 19 years. We serve folks in all 95 counties. Our focus, there's 4 attorneys, including me, have these handy-dandy sheets in the back, thanks to Kristen Hackett, a volunteer here today and also at TJC. It lays out the numbers of kind of who we are. We have a budget of about $1 million, 13 full-time equivalent folks. Our focus over the years has been to fill the gap. We're not funded by LSC, so we can do things that legal services is restricted from doing, but because we don't receive funds from LSC, we have limited our cases to healthcare in recent years. We have been the beneficiary of incredible pro bono help. We do 3 main things in recent years. We get Tennesseans health coverage. We make sure the system mirrors the law, and we connect everyday realities across the state to decision makers. And the 4th thing is we channel goodness, folks like you, to make a difference in everyday Tennesseans' life. So since 2006, we have received about $17 million in pro bono help from firms around the country, and have just been moved beyond words by the generosity and talent of folks, and how it basically is saving the lives of our clients. So the Benta B case, in Tennessee, we're the only state in the nation that has managed care on our Medicaid program. So wall-to-wall managed care. In other states, people who are very, very sick are exempted from managed care, but in our state, every single person, every single child has managed care. And so that means that the state pays HMOs a per member per month amount, and that and the incentive there is to not deny services that are very expensive. Doctor prescribes something, HMO determines whether or not someone gets it. There are legal rights to get what your doctor ordered, but it's fairly complex. So this is a video that a volunteer put together about a family who a pro bono, Brad Morgan, helped get the services the child needed, and it kind of basically shows what a difference it can make to have a lawyer standing with you. And so I'm going to show you this 2-minute video.
My name is Evelyn Manley. I'm a public health nurse. I work for the state of Tennessee at the Ray County Department of Health. I was 22 weeks pregnant when I found out. He had some suspicious ultrasounds and some suspicious blood tests, so they sent me to a specialist, and they did an amniocentesis and confirmed that he had Down syndrome. Yay, he says. And we worked through that, accepted it, and then I think he was about 2 and 3 or 4 months when I first suspected that he had autism. So we had him evaluated at Vanderbilt, and within the first 30 minutes the psychologists all agreed that he was autistic. So the youngest they ever diagnosed with Down syndrome and autism. When you have a child with special needs, you'll probably always have to push a little bit to make sure those needs are met. There have been difficulties. There's geographic difficulties, there are financial difficulties, there are difficulties just with individuals. But what we're getting is, great. They go into the community with us, they go to the school, so they see him in all these different settings and give great suggestions about how to manage his behaviors. So it could be better, but it could be a lot worse. Having Down syndrome, people think that that means that you're happy all the time and that you smile all the time and you're always hugging on people. And I think that's true for a lot of people with Down syndrome, but not for my son, because he also has autism. He is socially kind of withdrawn, but since he started ABA, he has changed. And one of the best memories I have is the first day that he came up to me and hugged me. The first time that he kissed me, he was 3 years old. So, yeah, that was a wonderful day. Our pediatrician, she gave us the name of the Tennessee Justice Center and the website. And I called up there and spoke with Katie. And I think the best thing about working with them is knowing that these are people who are doing this out of the kindness of their hearts. You know, attorneys who probably could be making money doing something else, but instead took their time to help us. They helped us in a really hard time when I wouldn't have been able to afford an attorney. They were a great advocate for my son and for our family. So, yes, I'm very grateful that they were there to help when we needed them.
So Brad Morgan in Knoxville took her case, and through the Ben-to-Be appeal process was able to get his ABA therapy restored. And you may remember my favorite law school case was Goldberg v. Kelly, and it basically says that when you have brutal need, you can't stop an ongoing service unless you have a pre-deprivation notice and appeal process. And that's kind of the foundation of the Ben-to-Be appeal process. And so making that real for moms of kids with special health care needs or adults with chronic illnesses is super important. And so we're going to talk a little bit about kind of how this plays out in Tennessee administrative procedures rooms all over the state. Okay, so the legal authorities are incredibly complex, and we have a gigantic binder. So if you want to take one of these cases, we have training just about this on video, and then we have a huge binder with like model pleadings. But this gives you a sense. It's a complex web of protections for people, but we'll hold your hand and make it really simple. But the big issues in many of these cases is it medically necessary? So her pediatrician said he needed to keep getting ABA, and the HMO said, you know what, he has progressed as much as he's going to progress. So the issue at the hearing was, is it medically necessary? And the Kaiser Foundation has found that in Tennessee we have the most restrictive definition of medical necessity in the nation. And so basically you need a lawyer to win these appeals. The state is represented by counsel. Oftentimes their HMO's counsel is involved in the case. So when we send clients into these hearings without attorneys, as we sometimes have to, their chances of winning are very, very small compared to going in with an attorney. So the definition of medical necessity in the law are these 5 elements. And the thing that is unusual in the nation is number 4. It must be the least costly alternative for diagnosis and treatment that's adequate for the medical condition. And the regulations for defining that say that includes if no service is adequate, if a delayed service is adequate. So it's hard to be cheaper than nothing because the least costly alternative is kind of hard. So part of determining what is adequate is laid out in this Ben-to-Be decision that Judge Nixon ruled that the medical opinions, you have to defer to the treating clinician if the treating clinician has is basing their opinion on objective evidence or on information in the patient's medical record. In theory, the treating clinician would know more than an HMO doctor who's never seen the child about whether or not Christian would benefit from ABA therapy. So the law says you have to defer to the treating clinician under certain circumstances, but in order to kind of balance that, it's a fairly complex analysis, which depends also on these objective evidence. And so objective evidence is there some treatise somewhere that says that kids with autism benefit from ABA therapy, and that's applied behavioral analysis therapy, which is basically trying to help kids respond appropriately when they're acting out or when their impulse control issues. So, of course, there's lots of medical opinions and objective evidence for things that are fairly common, and it's a little bit harder to find objective evidence for rare conditions. And so that's why the treating clinician, it's good to have a treating clinician who knows, is there any article anywhere, journal article anywhere that says this is needed? And if there is, and the clinician's prescription is consistent, then they have controlling weight. There's also a requirement that it not significantly deviate from the defendant's, and this says MCC, but basically that's what Tennessee calls their managed care plans or HMOs. If their opinion significantly deviates from the doctor, significantly deviates from the HMOs or from the states, then they can ask follow-up questions. Oftentimes we find that the opinions are, not, the HMO originally covered that ABA therapy for the child because they thought it was medically necessary. They just thought that the child needed it for a smaller number of weeks, and the doctor said, no, we actually need it for more weeks. And so the definition of significant deviation is they never said that this is something that wasn't needed. So basically that does not include, that is not a significant deviation if it's about the amount of a service. Again, we have all of this really complex thing laid out in a super simple way to go to a hearing, and actually Vanderbilt law students are making it into an app. So any pro bono attorney who takes a case could have an app that is free that will kind of lay out the questions. But I included all of this language in Judge Nixon's order just to give you a sense of why lawyers are really needed, because parents go into these hearings and they think, my doctor said this is needed, how could I lose? Well, the fact is the law is pretty complex. So no surprise, the number one practice tip is make sure that you have a treating clinician, whether that's a nurse practitioner or a mental health professional or a pediatrician or a doctor who just will make a recommendation. And optimally they testify in person or by phone, but they can also testify by declaration. The rules allow you to have an affidavit, a doctor do an affidavit, and if you give it to the other side 10 days before, then they have 7 days to ask for the ability to cross-examine. They often don't, and the affidavits generally come in and are proof of the medical necessity. The second thing is making sure, oftentimes doctors will say this is needed, and I can tell you that it meets all 5 elements in the medical necessity definition. But what they don't do is look back over the medical records and show why it's needed. And because the way the law is written, like finding lab reports, finding the original diagnosis of autism in the case of Christian is super important, because it isn't just what the doctor says, it's what the medical record says. So looking back through the medical record and attaching a copy of it is super important for getting a service, for getting a denial overturned. Okay, you guys follow? Are you with me? The next big opportunity in these cases is a notice issue. So when a doctor prescribes something and the HMO denies it, they have to send a notice that says why they denied it, and that's part of the Goldberg promise. And this is anytime there's a denial of a prescription, a termination of an ongoing service like home health or physical therapy, speech therapy, if they reduce the service, so a kid's getting 5 days a week physical therapy after an accident, and then they go to 1 day a week, they have to give a notice. And the notice has to come 30 days before the service is to be terminated. That gives the person enough time to say, hey, wait a minute, this is a mistake. You sent it to the wrong person. The notices are, in theory, supposed to lay out the information that you need to challenge that denial. Okay, so you have to say on the notice the type, amount, and service at issue, the statement of reason for the action taken, and they have to identify who's the clinician who said this service is going to be terminated. They have to cite medical records of the child, of the person losing the services that they relied on for the decision, and they have to say which of those 5 elements of medical necessity it doesn't meet. And to the extent that they say only one element is not met, then it's presumed that the other 4 are met. And then the final thing is just information about the appeal process. Where's it going to be? When's it going to be? You have a right to an attorney. Rarely does a client get denial that has all of these elements. Oftentimes, they don't look at the medical records before they deny it. They sometimes don't have a doctor who will put their name to the denial. And so if you can help folks by just looking at their notice, you can often win a case on that basis alone. Basically, if the notice isn't adequate, then they can't stop the service. So no adverse action can take effect unless the notice is adequate. So basically, you say go back to square one. Keep providing the ABA. We'd love to go to a hearing with you sometime, but the notice isn't adequate, so keep providing it until you can get it right. Oftentimes, this makes the HMO look back at the medical records and see, we really can't defend this denial, and so that's the end of the story. There's 1.3 million people on TennCare, and there's last year at TJC we handled about 900 individual cases. So as you might imagine, there's way more of these denials than we can ever handle, and so that's why I'm so happy to be here today. Next, we're going to talk about Wilson appeals. Any questions on the Benton B appeals? Okay, so the Wilson case was in the news a lot last year. Go ahead. Sorry, I just can't see. Go ahead.
Thank you. My name is Lisa Spells. I'm a speech pathologist with a legal background. So I'd like to go back to how we are identifying the clinical treatment person, because usually when it comes to going to court, you can use those specialists as forensic experts. Mm-hmm. And often the physicians can't come, mm-hmm. but if you have the rehab specialist come, you win your case automatically. Mm-hmm. I can tell you that. Mm-hmm. And the second thing is, if the specialist has not created a discharge summary report, then that client still has not been discharged, no matter what any other agency says. So it's unfortunate that you don't have enough attorneys who are willing to go into that area. It's really easy, guys, to win. It's also easy to get paid for it, and I'll talk to you about that later.
Yeah, the law actually says treating clinician, and so you're exactly right, that you don't even actually have to have a doctor. In the case of mental health issues, you can have a licensed clinical social worker, speech therapist, anyone who knows the issue about the issue that you're prescribing can be there. And oftentimes doctors can't be at the hearing but might join by phone. But we've won cases which is home health nurses testifying about these are the symptoms that we see every day in the child's home, and this is why it's needed. So another way that, and because this is shorter than usual, that you can keep the services the same is when the services are stopped, there has to be an adequate discharge plan that lays out what's the next step for this child. Sometimes HMOs just say, we cover this for 30 days and then it's ending because that's what we do. But the fact is, at the end of the 30 days, if there's not an adequate discharge plan that says what next, then the services have to continue. And that's in the context of some services like inpatient psychiatric care, residential care, home health. So thank you for pointing that out. So the Wilson case is a recent case in the last year, and it is, folks may have heard that there was a few changes in January in America. Catch her face right there. So basically in Tennessee, healthcare.gov went live in last October. And in other states, the people who applied at healthcare.gov were applying for subsidies. It's basically newly covered folks who were getting subsidies so they could buy private insurance on the marketplace. In Tennessee, we shut our Department of Human Services offices so that the people who generally process Medicaid applications, so these are pregnant women, babies, moms, people with severe disabilities and elderly, those folks for 40 years have gone to a local, in their county, Department of Human Services office, and they have applied for that program. Starting in October and completing in January, all of those folks were laid off in Tennessee. And everyone who wanted to apply for these services had to go to healthcare.gov. And as you might have remembered, healthcare.gov wasn't perfect. And it was actually never designed to process Medicaid applications, to be the only portal for Medicaid applications in the state. And so what that meant was pregnant women who were in mid-pregnancy who had applied for prenatal, basically for presumptive eligibility at a health department, they were supposed to gather the rest of their document. That presumptive eligibility lasts for about 45 days. Then they gather all of their financial information. They previously had submitted it to their county office, and then that gave them coverage the rest of their pregnancy. Well, when they got to the end of the 45 days and healthcare.gov didn't have any place to submit all their information, basically every pregnant woman in the state was without coverage for a period last year. Similarly, newborns. Healthcare.gov does not let you complete an application unless you have a Social Security number. And the funny thing is, when newborns are born, they have no Social Security number. So this case was about the kind of fallout of having no in-person process for application and having basically the most vulnerable people in the state applying for health coverage and not being able to get it. And I want to talk about Amy, who last week, a pro bono attorney, solved the problem that kind of Wilson created. So Amy was born in April 2014 with cystic fibrosis. Her mom applied for TennCare a few days later. She received a letter from the marketplace showing that she might be eligible for TennCare. She submitted additional information, like the hospital records show that this happened. It's written down in the hospital records. They requested a copy of the baby Social Security card in order to complete the application. And again, Social Security cards usually take 2 to 3 weeks. With a baby with cystic fibrosis, as you might imagine, the bills just were out the roof by 2 or 3 weeks. So basically, the family incurred so much debt in those few days between the time that she applied and the time that they actually completed her application that it would have made the family bankrupt for the rest of their lives. Through the Wilson order, which basically, I kind of jumped ahead, but basically she had a right to a hearing. And we didn't think she would have to go to a hearing because she applied. She did everything she was supposed to do, but the system said she didn't. And so she was basically being hounded by collection agencies. So Liz Sitgreaves from Dodson Parker and Brown took the case. Basically, it was set for hearing. She reached out to the attorney for the state and said, here's the proof, here's the hospital information, here's what the mom got from the marketplace. She applied on the date that she applied, not on the date that you all said she applied, and basically $150,000 in medical debt later, they won. So that, Liz says, it was easy. It was easy and it was fun, and you can do it too. And so we have lots and lots of these cases. So this is basically the law, the Medicaid law says that you can't take longer than 45 days to determine someone's eligibility for Medicaid. But because we don't have a system in our state, the state contracted with a corporation to build a computer system that had Tennessee-specific information. That fell through. So we literally are the only state in the nation that doesn't have a system that determines eligibility. And so healthcare.gov, which wasn't designed for Tennessee-specific information, is continuing to process those applications, and some people continue to get stuck in that in that tangled web. And in the Wilson case, basically, which we filed in July with Southern Poverty Law Center, National Health Law Program, Judge Campbell basically said, if somebody's waited over 45 days, they shall have a hearing. And that means that there's going to be lots and lots and lots of hearings. And in the case of Amy, as you could see, writing to them and just saying, hey, we don't really need a hearing because she applied, and maybe there's just some confusion between healthcare.gov and the state, but she applied, here's the proof. It was still set for hearing. We still had to get a pro bono attorney. That pro bono attorney was able then to solve it. But we have lots more of these coming. They continue. The class continues to grow. And literally, when I left the office, we had 7 cases set to going to hearing in the next few weeks. An example of that is a 42-year-old woman, single mom of 2 kids. She has no income. She applied by phone because, not surprisingly, many of our clients don't have access to a computer to apply on the marketplace. And so when she's asked for proof of application, when she applied by phone, she doesn't have proof of application. We called with her the federal marketplace. They had proof that she called on the day that she said she called. She had to have emergency heart surgery. Again, hundreds of thousands of dollars later, she has a hearing set, and she applied. But the question is, when did she apply, and will they go back to the date that she applied, that the federal government says she applied? And if so, then basically she has some peace of mind and security for her family going forward. Another case is an 11-year-old girl with severe disabilities. There's a category of Medicaid called spin down, and it basically is for middle-class families who have extraordinarily high medical expenses because of a new diagnosis, or because basically everybody is sick at once. If you have a huge amount of medical bills, you can kind of use those medical bills as frequent flyer miles, and they will, through this complex process, determine that you're eligible for Medicaid. So this 11-year-old girl has multiple disabilities. She's eligible in that category. Healthcare.gov does not have a way to apply for that category because many states don't have that category. And the states that do have their own system through which you go if you're eligible for, if you're applying for Medicaid in that state. So basically, she was approved for Cover Kids, a program for higher income kids that has some medical benefits but doesn't have comprehensive health benefits that TennCare does. So she's going without what she needs. Ironically, her 2 siblings in the same household with the same income have Medicaid. She doesn't. And that's set for hearing in the next couple of weeks as well. So all these cases are eminently winnable, but there's just so many of them, tens of thousands of people in this class, and they're all going to hearing at the same time. The state is hiring judges and hiring lawyers, and it could be really fun to win. So last kind of case is Choices. Choices is a program for people who need long-term care. So people who are in nursing homes, and people in our state, everybody who is eligible for nursing home care, we now have moved all of that into a managed care system. So you can either get community-based services or you can get nursing home services, and the HMO decides. And these folks are elderly folks who need care for the rest of their lives, or people who are not elderly but who basically are appropriate for institutionalization. They have such huge disabilities that they can't do activities of daily living. And talk about this client, Tommy. She's 88, suffers from COPD, hypertension, arthritis, mental health issues as well. She worked cleaning houses until she was late into her 70s. Several years ago, her husband of 40 years died, and they had no children. So her niece, Vicki, who's pushing her there, became her primary caregiver. Vicki works full-time. She goes to school full-time. She's trying to care for this woman who really requires round-the-clock care. She applied for Choices because she had she had issues with so many activities of daily living, but they turned her down. And so basically, she was trying to get coverage to get into a nursing home so that her needs could be met. Vicki went to a hearing on her aunt's behalf. She said, I can do this, I've done this before. We gave her all the information, and she went to the hearing and lost the hearing. And some incredible pro bono attorneys, David Wicker, Walt Halvius, took the case to Chancery Court and got the denial overturned. Now she's getting nursing home care and doing well. Those cases, there's kind of three main problems that come up in those cases, and all of them require help. Basically, you have to have trouble with activities of daily living in order to qualify, and it's a pretty complex matrix of how they determine whether it's not just like if you have trouble with 4 activities of daily living, then you qualify. It's a more complex matrix, but again, if you want to take one of these cases, we have a whole training just on Choices. You also have to require skilled care, rehabilitative services, and if all you have is dementia and you don't have a physical disability, that doesn't qualify you. So it's very hard to get a determination that you qualify medically. It's also hard to qualify financially. You have to make about a little bit less than $2,200 a month. So this program is for higher income folks, but many clients make a little bit more than that in pension, and so and also the Wilson issues that we talked about. When January 1 came, the computer system that determined Choices, without a computer system, it was really hard to determine Choices. So lots of folks in nursing homes were left without a determination of their eligibility. So these are the 3 main problems that we're seeing on a pretty regular basis. People are denied medical eligibility even though they really are eligible. So you have to go to the doctor and get proof that this person really is having a hard time, or you can go to a family member and show this person really can't feed themselves. And then the problem number 2 is related to having no computer system. Many people are waiting 6 and 8 months. And as you might imagine, this is not a population of folks who can wait 6 or 8 months for determination of whether they can get long-term care. But when an attorney writes about this, those problems are almost always resolved quickly. And then the financial eligibility sometimes is a problem because they just use they just analyze it wrong, or they apply a monthly income statement to someone whose income fluctuates. So those are the 3 big issues that come up for Choices folks, and this is a really important program for our seniors and folks with just severe disabilities who will need help for the rest of their lives. And their ability to have the last years of their lives in dignity, it's just so important that the Choices program work. And in a managed care system, the incentives are not quite right for folks to get the full benefit of everything they need. So that's all the stuff I have to cover, but I can go back over stuff more slowly or take questions. Yeah.
My question is, under the Choices program, are clients or consumers or patients still seen in home health settings? And are you having new cases in home health settings have been denied? I don't remember what I said.
Yeah, basically your question was, do you get home health with the Choices? The Choices program is basically however much it costs to institutionalize a person, that amount of money can be used either in an institution or in the community. And so it is a way to look at a person's health needs in a cost-neutral way and say, if you want to stay at home and you don't cost us any more to stay at home, then we'll do that. And that makes a lot of sense. but we're having trouble getting people eligible for the program at all. So it isn't a question of, will they only put them in an institution and not put them at home? It's a question of getting them eligible at all. So we have people who actually go into nursing homes paid for by Medicare, and then Medicare ends and Medicaid should pick it up, but Medicaid's saying they're not sick enough to qualify for nursing home care. And if they're not sick enough to qualify for nursing home care, they're not sick enough to qualify for any community-based services either. And so clients literally being threatened to be evicted from nursing homes who in their late 80s with dementia and with all sorts of issues that, they really wouldn't survive 48 hours. So, yeah, I don't know if that answered it.
What is the status, Michelle, of what is the status of the state's appeal? I understand that they did appeal Judge Campbell's preliminary injunction in the Wilson case. Have they simply conceded that they're going to drop the appeal now that they're doing hearings, or where are you all in that process?
The appeal will be heard this summer, so it's been fully briefed, but the oral argument hasn't been set, but we expect it will be set for this summer. But they're in their papers on the brief, they don't say we're not going to do, they say they're complying with the order. And so they're not arguing, please don't make us comply with the order. They're just basically saying, he didn't have to make us do this. We would have done it anyway. So the fact is, there are people like Amy who basically got on because the order came down and it said, you must either give people a hearing or they can't wait longer than 45 days. So lots of people got covered at that point, but the start date was wrong. So there's that wave of people, and then there are new people applying. So every kid who comes through today and wants to apply for spin down Medicaid, so these are kids with cancer and kids with severe asthma, newly diagnosed terminal illnesses, there's just literally no way to apply today. And so those are new class members. The class continues to grow. And yeah, I mean, until there's a new computer system, I don't know how we get to a place where that's specific and it covers all of Tennessee's categories of eligibility. I don't know how we get to a place where the class starts shrinking and we're just dealing with the start date issues. Other questions? Okay, go ahead.
I recently had a friend that did get approved for choices, and at first they weren't approving her. Basically the test was, and I don't know if this is correct, if she was able to get out of the bed and go to the bathroom, they weren't going to approve her. I just can't even believe that. She couldn't remember to take pills, couldn't remember to bathe herself, dress herself, nothing. And it's just crazy.
Right, yeah. Yeah, I mean, that is not an accurate test, but the issue is a lot of times folks give a test that isn't quite accurate. And so as soon as we hear somebody's denied and we say, well, what was the basis of the denial, we can almost always get to a point where they're applying the wrong standard.
Yeah, we got them to come back out, and then the second social worker that came out did approve her. She's getting 20 hours a week now, 4 hours a day, 5 days a week, and it's been a godsend because, I mean, everybody else was having to pitch in, and I was paying someone to come in once a day.
Yeah, I mean, it is, their kind of first knee-jerk reaction is always to deny, and so to the extent you can get the information and look at look at what the medical information shows, you can almost certainly win if the person is severe enough. I mean, one example of Choice's case that we had was a mom named Beverly. She needed a liver transplant. She'd been a nurse her whole life for 40 years, and she was fairly middle class, but because she had a bad blood transfusion when she was younger, she basically got hepatitis without knowing it. So she needed a liver transplant. She was 60, and she needed a liver transplant to survive. Now, she didn't, before she got so sick, she didn't need help with activities of daily living, but as she got sicker and sicker, she was basically being discharged to hospice, and they didn't know that the fact was because she was so sick, she couldn't do any activities of daily living. And so we were able to get her approved for Choices. She was able to get the liver transplant, and she's doing very well now. So I think that just making sure that we're thinking not just about people who for all times can't do activities of daily living, but sometimes they just get so sick they can't do them, and we can get folks approved that way.
Yeah, it's definitely been a blessing. I've been sending a physical therapist out, an occupational therapist, and then a caregiver 4 hours a day.
So it makes a huge difference for people's quality of life.
Looping back to an early part of your talk, you indicated that you all have a good handout or a good book or help guide. Mm-hmm. How can we access that again?
So how about if people just email me, or if you have a sign-in sheet, I can just send you a link to it. But basically, you can email me at mjohnson@tnjustice.org. And we have it on a disc, and we have a tape that's really very boring. And then we also have a binder. We can send you the binder. And then these Vanderbilt students are finalizing an app, which I'm really excited about because I think it'll make it super easy to take the cases. It just walks you through the questions. So we won't have the app yet, but if you send me information as we have it, we'll get it to you. Sure. Other questions? Well, thank you guys so much for spending your day figuring out how to help my clients, because it really, I can't tell you, it really, really saves their lives when lawyers get involved. And even in the case where you can't win the appeal, just knowing that someone is telling them that they matter means so much. So thank you for all you do and for listening to me drone on and on. See ya.
Good afternoon. Now I have two mics. I'm sorry. My name is Rod Bragg, and I'm with the Tennessee Department of Mental Health and Substance Abuse Services. I'm the Assistant Commissioner for Substance Abuse Services, and this is really exciting what you're all doing today. I was invited to come and talk for 5 minutes or less, and that's all I'm going to do, to tell you about a faith initiative that we have going on with the state. Now, that may sound strange, the state doing a faith initiative, separation of church and state. But we believe, particularly in the mental health and particularly in the substance abuse field, that the faith community is vital to the healing of people as they recover from mental health or substance abuse issues. We have an initiative called the Faith-Based Community Initiative for Substance Abuse Services, whereby we're training churches and other faith-based organizations on how to minister to people with a substance use disorder. I'm a former minister myself, so I'm often out at the churches speaking with folks. And once they meet certain criteria, we are then certifying them, a state certification, as a recovery church or a recovery faith-based organization. And these are churches. There'll be an ambassador, a faith-based ambassador, in each church that will kind of lead the movement, and we'll be helping churches to really minister in the appropriate way to people with a substance use disorder. Primarily hosting 12-step groups like Alcoholics Anonymous or Narcotics Anonymous. A lot of churches do that. Hosting other recovery-type support groups or case management or transportation. And also having, encouraging staff or church staff to have a recovery Sunday, where from the pulpit, which is a very important place, the pastor or whoever's speaking that day will talk about what it means to live a life of recovery and how that is important to one's faith journey. I'm a strong believer that substance abuse addiction is not only a brain disorder, a physical condition, but it's also a spiritual condition. And until both are addressed appropriately for that person, healing, I don't think, often takes place. Now, there are many paths to recovery, of course, but I believe that combination is really vital in helping people live a life of fullness, of health, of recovery in their community. So I just want to take the opportunity to again say thank you for what you're doing and to let you know about this initiative. If anybody would like to contact me about it, I can be reached at, my name is Rod, R-O-D, Bragg, B-R-A-G-G, and it's Rodney, R-O-D-N-E-Y, only my mother calls me that, .Bragg, B-R-A-G-G, at tn.gov. So thank you all for your time. I appreciate it.